The laugh started low. It began somewhere behind the judge's closed mouth, a kind of pressurized amusement he made no effort to contain, and it moved through the wood-panelled courtroom of Division 7 like a slow current. A few people in the gallery shifted in their seats. The court stenographer, a young man named Dale, who had worked for the county for 8 months, glanced up from his machine and then looked immediately back down. Margaret Foss, the clerk of court, stood near the side door with a manila folder pressed against her chest. She did not look away. The woman at the plaintiff's table did not flinch. She stood with both hands resting flat on the edge of the table, a yellow legal pad in front of her, and a slim silver pen clipped to the cover of a worn portfolio binder. She had pressed her grey blazer the night before. She had arrived 40 minutes early. She had organised her exhibits in numbered tabs the way she had watched attorneys organise theirs for 11 years, because she had been inside this building, inside rooms like this one, for 11 years. Not as a litigant, not as a lawyer, as the person who made sure every word spoken inside these walls was captured, preserved, and permanently on the record. Her name was Naomi Elias. She was 38 years old. She was representing herself, and the judge was laughing at her brief. "Counsel," he said, and then he stopped himself and corrected the word with the kind of audible relish that told you the correction was the whole point. "Ms. Elias, I have reviewed your filing. I want to make sure I understand. You're citing Simmons versus Harbourview Properties as the controlling authority for your fair housing claim." He paused. He looked out at the gallery. "Is that correct?" "It is, Your Honour." He made a sound. Not quite a laugh again, but its cousin. "Simmons was decided in 1987 in the Ninth Circuit. We are in the Fifth Circuit. You do understand that Ninth Circuit precedent carries no binding authority in this courtroom." "I understand that, Your Honour." "Do you?" It was not a question. "Because your entire brief appears to rest on a case that has no legal weight in this jurisdiction. I'm not sure what you expected me to do with this." The ventilation system in Division 7 produced a low mechanical hum, a constant underpressure of recycled air that filled every silence. Naomi had spent years learning to work inside that sound. She knew its rhythm the way a musician knows the tempo before the first note is struck. She said nothing yet. She waited. What happened next is what this story is about. But before we get there, before the bailiff crossed the floor and leaned down and put his mouth near the judge's ear, we have to go back 11 years. We have to go back further than that, actually. We have to go all the way back to a one-bedroom apartment in the Eastwick neighbourhood of Philadelphia, where a woman named Ruth Elias kept her legal briefs in a plastic storage bin under the bed. Let me take you there. Ruth Elias was not a lawyer. She had wanted to be one. She had applied to 3 law schools in 1971 and been waitlisted at all 3, and the letters that came back, polite and institutional and final, went into the same bin as her annotated copies of the Federal Rules of Civil Procedure. She was 42 years old when she finally understood that the system was not going to open the door she was standing in front of. So she walked around to the side of the building and built her own entrance. She became a paralegal. She worked for 26 years at a small civil rights firm on South Street, and she was the person the attorneys brought their hard questions to, because Ruth's memory for case law was not a professional skill. It was something else. It was something closer to what her pastor would have called a calling. She could read a statute once and recite it 3 weeks later in a conversation about something else entirely. She could find the narrow procedural opening in an adverse ruling the way a seamstress finds the weak thread in a fabric by running her fingers over it until she felt the give. The lead attorney at the firm, a man named Arthur Deacon, who had practiced civil rights law since before Ruth was born, once told her that she had the finest legal mind he had encountered in 40 years of practice. He said it quietly in the hallway outside the conference room with his coat already on his way to catch a cab. Ruth thanked him without looking up from the motion she was proofreading. She finished the proofread before she went home. She was not being modest. She simply understood that the compliment and the work were different things, and the work was the only one she had direct control over. Ruth came home from South Street every evening, and she sat at her kitchen table with the briefs the attorneys let her borrow, and she read them the way some people read scripture, not for the conclusion, but for the architecture underneath. She was trying to understand how an argument was built, how a precedent was chosen over another precedent, how a citation, placed correctly, could change the weight of an entire filing. She kept a legal pad beside her and she wrote what she noticed. She bought the pen in 1979. It was a Scheffer Targa, second-hand from a shop on Walnut Street that smelled of pipe tobacco and old paper. It cost her $4.50. The initials R.E. were already on it from a previous owner, which she took as a sign. She used that pen to annotate every brief she studied for the next 31 years, pressing small, careful notes into the margins in handwriting so precise it looked typeset. The pages of her annotated briefs looked, when you opened them, like a conversation between the law and Ruth, with the law speaking in print and Ruth answering in miniature. Every question she had and every connection she had found written in that compressed, careful hand beside the passage that prompted it. When Ruth Elias died, 3 years before this story, she left Naomi 2 things. She left her the plastic bin full of annotated case law, packed into 11 folders organized by subject, and she left her the pen, clipped to a note card that said, in Ruth's compressed handwriting, "The law belongs to whoever studies it hardest. Don't let them tell you different." Naomi had carried the pen every day since. She had come to the courtroom the way most people come to a place they love and are required to leave, without fully understanding how deep the attachment had grown until the leaving was upon them. She started as a freelance transcriptionist at 27, working county overflow hearings for $42 an hour. Within 3 years, she was a contracted court reporter for the circuit, assigned to whatever division needed coverage. She had worked in family court, probate court, criminal arraignments, civil trials. She had sat in Division 7 more times than she could count. She knew Judge Warren Colby's courtroom the way you know a room you have cleaned every week for years. She knew that he tapped his ring against the bench when he was about to rule against someone. She knew that he took his reading glasses off when he was about to make a speech. She knew that he had been on the bench for 22 years and that he had accumulated, in that time, 114 formal complaints from pro-SE litigants, most of them low income, most of them people of colour, most of them individuals who had come before him without legal representation and left without a fair hearing. She had sat in this room, in her usual position at the court reporter's table to the left of the witness stand, and she had watched what happened to people who came before him without credentials to display. There was a woman she thought about often, a schoolteacher named Mrs. Alderman, who had come to contest a property lien pro-SE and had cited 4 cases in support of her position, and Colby had interrupted her at the 3rd one to say that the court's time was not a practice session. Mrs. Alderman had pressed her lips together and gathered her papers with shaking hands, and Naomi had typed every word of it at 225 words per minute without letting her face move. The lien was upheld. Mrs. Alderman walked out with her file folder clutched against her coat. Naomi had gone home that evening and pulled out the legal pad from her portfolio and looked up the cases Mrs. Alderman had cited. 2 of them were controlling in the 5th Circuit. The 3rd was persuasive authority from a related jurisdiction. The 4th was not perfectly chosen, but the first 2 were sufficient. Mrs. Alderman's argument was not wrong. It was just unprotected. She did not editorialize in the transcript. That was the discipline of the work. But she read. She always read. She had transcribed some of Colby's hearings herself. She had typed his words at 225 words per minute, and she had not let her face change. That was the discipline of the work. You capture the record. The record is what it is. You do not editorialize in the transcript. She had read the record, though. She had read all of it. She had read it the way her grandmother read briefs, with the pen in her hand and a legal pad beside her, working through every citation, every ruling, every procedural decision. And when her landlord refused to renew her lease after she filed a noise complaint against a neighbouring unit he managed, and when she discovered that 3 other black tenants on her floor had received the same non-renewal notices within 60 days of filing similar complaints, she knew exactly what she was looking at. She also knew she could not afford an attorney, so she filed the complaint herself. She spent 4 months on the filing. She worked on it after her shifts ended, at the small desk in her bedroom with Ruth's bin of case law open on the floor beside her, cross-referencing citations, checking procedural requirements, mapping the argument with the methodical care her grandmother had taught her. She wrote and rewrote the statement of facts 7 times. She was not pretending to be a lawyer. She was doing what her grandmother had done for 31 years. She was using the law as the tool it was designed to be, and she was using it precisely. On the 4th draft, she found the Coleman decision. She had come across a reference to it in a footnote in one of Ruth's annotated briefs, a brief Ruth had been studying in the months before she died. The footnote said only, 5th Circuit, Housing, retaliation pattern. See also. Ruth had drawn a small circle around the words and written the date beside it. Naomi spent 2 evenings tracking the full text of the decision through the law library database at the central branch on Vine Street, where she had a card since she was 9 years old, the same library where Ruth had taken her every Saturday morning for a decade. She printed the Coleman decision on the library printer, 12 pages, and she sat at a table near the back windows and read it 3 times, with the pen in her hand, making her own marks in the margins the way her grandmother had taught her. Coleman established that 3 or more non-renewal notices issued within 60 days of protected complaints from tenants at the same property, without individualized documentation of cause, constituted a facially sufficient pattern of retaliation under the Fair Housing Act. The standard was exactly what Naomi's situation described: the 4 non-renewal notices on her floor, the 60-day window, the absence of any documented cause beyond the complaint filings. She wrote the word Coleman at the top of her legal pad and underlined it twice. Margaret Foss had been the one to tell her, quietly over coffee in the break room one afternoon, 6 months before the filing, that there was a procedure for pro se civil complaints, that the forms were online, and that the filing fee could be waived on financial hardship grounds. She had said it in the way careful people say important things, without emphasis, as a piece of passing information, one professional leaving a door slightly open for another. Naomi had written it down. 8 months later, she used it. The opposing counsel was a man named Jeffrey Sandler, who worked for a property management firm downtown. He had attended this type of hearing many times before. He arrived at 10:08 a.m. in a charcoal suit, set his briefcase on the defense table, and glanced at Naomi, the way people glance at a piece of furniture they have not decided where to put. What he did not know, what he had no way of knowing, was that Naomi had already read his motion to dismiss. She had read it on the bus that morning, sitting in the seat closest to the window with the portfolio on her lap and her coffee cooling in the cup holder of the seat arm. At the 3rd paragraph of his jurisdictional argument, she had stopped and read the paragraph again because Jeffrey Sandler had cited Marchetti versus Westfield Realty as controlling precedent for his position that the complaint failed to meet the threshold for a fair housing violation. She knew Marchetti. She had transcribed a hearing that cited Marchetti, and she knew that Marchetti had been partially overruled 18 months ago by the 5th Circuit in Coleman versus Paramount Properties, a ruling that Sandler's motion did not acknowledge and did not address. The bus passed through 2 stops while she sat with that. A woman with a stroller got on and settled near the front. A man in a postal uniform fell asleep immediately against the window across the aisle. She wrote a single line on her legal pad. She clipped the silver pen back to the portfolio cover. She looked out the bus window at the city going past, the morning light flat and grey, and she breathed slowly. She arrived at the courthouse at 9:35 a.m. She went through security, nodding at the guard she had known for 4 years, and she walked the corridor toward Division 7, the way she had walked it hundreds of times before, past the water fountain that had been marked out of service for 3 months, past the bulletin board with its outdated procedural notices, past the door to the clerk's office where Margaret Foss was already at her desk. Margaret looked up through the glass partition as Naomi passed and gave a small nod. Naomi nodded back. She took her seat at the plaintiff's table and she set her portfolio in front of her, opened it to the legal pad, and placed the numbered exhibit folders to her left in the order she would need them. The courtroom was empty except for Dale, the stenographer, who was testing his machine. She had trained with Dale's predecessor and had known Dale for nearly a year. He looked at her briefly when she sat down, then looked back at his machine. He did not say anything. That was the etiquette of the room. The hearing was called at 10:15 a.m. By 10:38, Judge Colby had made his feelings about the complaint known through a combination of sighs, pauses, and precisely calibrated skepticism. He had asked Naomi 3 times whether she understood the concept of standing. He had asked her once with a studied even-handedness that did not quite conceal what it was covering, whether she had considered consulting with an attorney before filing. When she cited the procedural basis for her standing under Section 3604 of the Fair Housing Act, he nodded slowly in the way that means the nodding is not agreement. There were 11 people in the gallery that morning. 4 of them were law students from the nearby university attending for a civil procedure observation requirement. 2 of them were people waiting for the next hearing. One was a woman with a 3-ring binder who appeared to be taking notes on her own case. One was a retired man who had been coming to Division 7 hearings for years with no explanation anyone had ever been able to determine. and one was the woman in the third row from the back on the left side, with close-cropped silver hair and a lanyard turned face down against her chest, who had arrived at 9:47 a.m. and had not shifted in her seat once in the 50 minutes since. The four law students exchanged glances when the judge interrupted Naomi the second time. One of them wrote something in his notebook. Another looked down at her phone under the gallery rail, then put it away. Then she presented her central argument, citing Simmons as one supporting authority among three. And he laughed. The laugh lasted perhaps 4 seconds. It was not theatrical. It was worse than theatrical. It was casual. It was the laugh of a man who has decided, before the sentence is finished, that the person speaking has nothing to teach him. One of the law students stopped writing. The woman with the 3-ring binder looked up from her own papers. "Miss Elias," he said, "I am going to be direct with you because I think that serves everyone's time better. This complaint does not appear to have a viable legal foundation as presented. The central authority you are citing is non-binding. Your damages calculation rests on an assumption about retaliatory motive that you haven't evidenced, and I am inclined to grant the motion to dismiss at this point unless you have something substantive to add." He picked up his pen. He began to write. Naomi's hands were still on the table. Not gripping. Still. Her face did not change. If you were watching from the gallery, you might have thought she was listening to something very far away. She pressed 2 fingers against the portfolio cover, against the hard ridge where the Schaefer targa was clipped, and she felt the cool of the metal, and she thought of Ruth, and she said, "Your Honour, may I be heard?" It was not a request with rising inflection. It was a statement, a flat, declarative claim on the floor of the room. He stopped writing. He looked at her over the rim of his glasses. "You're citing Simmons as persuasive authority, which I intended as supplementary, not controlling. The controlling authority for this claim in the Fifth Circuit is Coleman v. Paramount Properties, decided 18 months ago by this circuit, which held that a pattern of non-renewal notices issued to tenants following protected complaints constitutes sufficient evidence of retaliatory motive to survive a motion to dismiss. Mr. Sandler's motion does not cite Coleman and does not address it." Silence. The ventilation hum. Jeffrey Sandler had gone very still at the defense table. His hands, which had been loosely folded on the table in front of him, did not move. His junior associate, a young woman seated beside him with a legal pad, looked at the top sheet of that pad, and then looked at Sandler, and then looked carefully at the table surface. One of the law students in the gallery had turned a page in his notebook to a clean sheet and was writing quickly. "I am also prepared," Naomi continued, "to enter into the record 3 declarations from other tenants at the property, all filed with this complaint as Exhibit D, establishing the pattern the Coleman standard requires." Judge Colby put down his pen. He looked at her. Not the way he had been looking at her. Differently now. The quality of the attention in the room had shifted, and everyone in the gallery felt it shift, the way you feel a change in air pressure before a storm. The woman with the 3-ring binder had set it down on the bench beside her. The retired man who came to these hearings with no explanation sat with his elbows on his knees and his chin in his hands, and his eyes on Naomi with the particular focus of someone who has been waiting a long time to see something. He said, "Counsel has not addressed Coleman." "No, Your Honour." "Mr. Sandler." Jeffrey Sandler cleared his throat. "Your Honour, we would respectfully request an opportunity to supplement our briefing in light of a case decided 18 months ago in this circuit," Judge Colby said. His voice had changed registers. It was quieter now, lower. "Which you did not cite. In a motion you submitted to this court." The gallery was very still. It was at this moment, 10:52 a.m. by the clock on the wall above the door, that the bailiff, a man named Thomas Okafor, who had worked Division 7 for 7 years, leaned away from the side wall where he had been standing with his hands behind his back. He walked with deliberate, quiet steps across the open floor between the gallery rail and the bench. He leaned down. He put his mouth near the judge's ear. Judge Warren Colby went still. Not the stillness of thought, a different kind. The stillness of a person who has just received information that rearranges everything they thought they understood about the room they are standing in. He looked up, slowly. He looked at the gallery, at the third row from the back on the left side, at the woman sitting there with a notepad on her knee and a lanyard around her neck. She was in her late 50s, with close-cropped silver hair and the particular composed attention of someone who has been watching courtrooms for decades. She had been there when he arrived that morning. He had assumed she was a law student. He had assumed this because he had assumed, and he had not looked more carefully. The bailiff straightened up and returned to his position along the wall. The judge's ring tap had stopped. The pen lay flat on the bench. In 22 years on the bench, in 114 complaints and however many thousands of hearings, Judge Warren Colby had never been observed personally and without prior notice by the Chief Justice of the State Supreme Court. Chief Justice Adeze Nwosu was conducting a judicial performance evaluation. She had been conducting them for the past 6 weeks, visiting the courtrooms of 6 circuit judges whose complaint records had triggered a review by the Judicial Oversight Commission. She had visited Division 7 this morning without announcing herself. She had signed in under her middle name. She had sat in the 3rd row from the back on the left side, and she had watched everything, from 9:47 a.m. when she arrived, to the laugh, to the attempted dismissal, to the moment a woman in a grey blazer cited Coleman versus Paramount Properties from memory without looking at her notes. The Chief Justice had written 4 things on her notepad. She did not look up from it now. Naomi stood at the plaintiff's table. She had not turned around. She did not know yet who was sitting in the 3rd row. She only knew that the judge's posture had changed, that the room had changed, and that the air in Division 7 had the quality of a held breath. Judge Colby set down his reading glasses. He looked at Naomi directly. "The motion to dismiss," he said, "is denied. Ms. Elias, your complaint will proceed. The court will set a date for the full evidentiary hearing, and Mr. Sandler, you have 14 days to file a supplemental brief that addresses Coleman. That is all." He rose. The bailiff called the room to order. The courtroom stood. Naomi stood with everyone else. She did not exhale visibly. She did not turn to the gallery. She reached down and picked up the silver pen from the portfolio cover, and she held it between her fingers for a moment, the familiar cool weight of it, and she thought of Ruth. Let me tell you what happened after. Margaret Foss came to find Naomi in the hallway outside Division 7 at 11:10 a.m. Margaret had worked for the county clerk's office for 19 years, and she had watched Naomi for 3 of them. She had watched her arrive early and stay late, and she had watched the care with which Naomi prepared her complaint, because Naomi had quietly asked her once about the proper formatting requirements for pro-SE filings in civil division. And Margaret had answered the question and then, without being asked, made copies of the procedural guide and left them on Naomi's desk. She had done one other thing, which she had not told Naomi about until now. 8 months earlier, when Naomi's complaint was first docketed and the division assignment came through as Division 7, Margaret had looked at that docket entry for a long moment and set her coffee cup down. Then she had gone to her computer and pulled the performance complaint file she maintained as part of her administrative duties, the one with 114 entries, and she had added a note at the top flagging the case as one to watch. It was not a formal procedural step. It was simply a record written by a woman who had been inside this building for 19 years and who understood that the record, kept carefully, was the only protection the institution reliably offered. She had sent that file to the Judicial Oversight Commission 6 weeks before the hearing date. She had not mentioned it to anyone. Margaret stood in the hallway with the manila folder in her arms, and she looked at Naomi, and she said, "She introduced herself to me on her way out. Chief Justice Nwosu. She asked me the name of the woman at the plaintiff's table." Naomi was quiet for a moment. "What did you tell her?" "Everything I know," Margaret said, "which is more than most people think." Chief Justice Nwosu's formal evaluation of Division 7 was filed with the Judicial Oversight Commission 12 days later. It was 91 pages. The section concerning the conduct of the hearing of November 14th covered 11 of those pages and included a specific notation about the treatment of the pro-SE plaintiff and the procedural irregularities in the bench's initial response to the complaint. It also included a notation about the quality of the plaintiff's legal preparation. That notation was 3 sentences long, and it cited Coleman versus Paramount Properties by name. Judge Warren Colby was placed on a supervised performance improvement protocol beginning in January. Under the protocol, a judicial performance monitor attended Division 7 2 days per week for 8 months. He did not preside over Naomi's evidentiary hearing. That hearing was reassigned by administrative order to a visiting judge from another circuit. The evidentiary hearing took place on a Thursday in March, 9 months after Naomi filed her complaint. She presented her case in 2 hours and 23 minutes. The visiting judge awarded her $14,200 in damages and issued a formal finding that the landlord's pattern of non-renewal notices constituted retaliatory conduct under the Fair Housing Act. The ruling applied to Naomi's case, but the formal finding of retaliation was a matter of public record. The 3 tenants whose declarations she had entered as Exhibit D, the 3 neighbours who had signed their names to statements about what had happened on their floor, each filed their own complaints within 60 days of the ruling. The court clerk logged them in the system. Naomi did not tell them to file. She had simply, when she was gathering declarations, told each of them that the forms were online and that the filing fee could be waived on financial hardship grounds. Said it the way Margaret had once said it to her, without emphasis, as a piece of passing information. Jeffrey Sandler did not attend the hearing. He sent a junior associate. Margaret Foss attended. She sat in the second row on the right side with a cup of coffee from the cart in the building lobby, and she did not cry during the ruling, but her mouth pressed together very tightly, and she looked at the ceiling for a moment before she looked back down. After the hearing, she waited in the hall. When Naomi came through the courtroom door, she stepped forward and put both hands around Naomi's right hand and held it for a moment without saying anything. Then she said, "Your grandmother would have found a procedural error in the visiting judge's order and fixed it before anyone noticed." She meant it as the highest possible compliment. Naomi did not celebrate in the courthouse. She walked to the bus stop on Broad Street and she sat down on the cold metal bench, and the city moved around her with its ordinary indifference, the buses and the pigeons and the sound of traffic. She opened her portfolio and she uncapped the silver pen and she wrote one line on the top of a clean page. She wrote, "It held." She did not mean the case. She meant the thing her grandmother had told her, the thing Ruth had pressed into the margins of briefs for 31 years and finally compressed into a single sentence on a note card. That language, that knowledge, that accumulated precision belonged to whoever had done the work of building it. The building could not be repossessed. Not by a laugh, not by a dismissal, not by 22 years of institutional authority aimed in your direction. 2 months after the ruling, the Judicial Oversight Commission published its annual report on the Performance Evaluation Program. It included anonymized summaries of notable hearings observed during the review cycle. One of those summaries described a pro-SE plaintiff in a fair housing case who had, without notes, cited controlling circuit precedent that opposing counsel had failed to address, and whose preparation had been formally described by the evaluating justice as a model of procedural competence. It did not use Naomi's name. It did not need to. The law student who had turned to a clean page in his notebook during the Coleman citation emailed his civil procedure professor that evening. The professor forwarded the email to the dean of the law school's Access and Equity Clinic with a note that said, "This is the kind of person we should be connecting with." That email arrived in the same month as the Chief Justice's letter. Chief Justice Nwosu sent a letter. Not to the Commission, directly to Naomi, addressed to her home in a white envelope with the state seal in the upper left corner. The letter was 2 paragraphs. The first paragraph said that the Chief Justice had observed her hearing and wished to acknowledge her preparation and her composure. The second paragraph said that the Chief Justice directed a mentorship and court access program for individuals seeking to enter the legal profession through non-traditional pathways, and that a scholarship in the program bearing a named endowment was being established, and that the Chief Justice would be honoured if Naomi would consider whether her grandmother's name might belong on it. Naomi sat with that letter for a long time. She sat with it in her kitchen, at the small table by the window, with the bin of Ruth's annotated briefs on the floor nearby and the silver pen on the table in front of her. The morning light came through the window at a low angle and caught the pen's barrel and held there, warm and still. She thought about Ruth at 42, reading a rejection letter in a 1-bedroom apartment in Eastwick. She thought about 31 years of precision and patience and love for a thing that had never formally let her in. She thought about what her grandmother had built in the margins of documents no one was ever going to read except her granddaughter, sitting cross-legged on the floor of a dead woman's apartment with a storage bin open in her lap. She thought about the library on Vine Street, the Saturday mornings. Ruth's hand on her shoulder steering her toward the law section, saying, "Everything you could ever need to know is in here somewhere. Your job is to find out where." She picked up the pen. She pulled the letter toward her. In Ruth's compressed, careful script, she wrote the name in the margin of the second paragraph, above the space where Chief Justice Nwosu had offered it. Ruth Elias Legal Access Scholarship. She looked at it for a moment. Then she opened the bin on the floor and she took out the top folder, the one labelled Civil Rights, Federal, and she set it on the table and opened it to the first annotated page. The margins were full. Every inch of available white space held Ruth's small handwriting, crossing back and forth with the text, asking questions, making connections, noting what had been proven and what still needed to be. Naomi ran her thumb along the bottom edge of the page and felt the slight indentations where the pen had pressed. She held the pen against the paper for a moment after writing it. The ventilation system in her building made a low sound, the ordinary hum of a building breathing, and she listened to it, and she breathed with it, and outside the window the city went about its business as if nothing had changed. Something had changed. Here is what you need to understand. The law was not designed to welcome Naomi Elias. It was not designed to welcome her grandmother. The rooms that Naomi walked into for 11 years were not built with her standing at the table in mind. But the law, the actual text of it, the case law and the procedural rules and the precedent stacked carefully across decades, belongs to whoever has done the work of learning it. That is the gap between the institution and the law. The institution can laugh. The law does not laugh. The law sits in a storage bin under a bed in a one-bedroom apartment and waits for the person who is willing to read it carefully enough. If you have ever been in a room where someone laughed at something you had built, where the authority in front of you decided before you finished your sentence that you had nothing worth hearing, think about what Naomi did at that table. She did not argue. She did not raise her voice. She waited for the breath to end, and then she said what she knew, and she knew it because she had prepared the way her grandmother had taught her to prepare, not for applause, but because the work itself demanded precision. Ruth Elias never got to stand at that table. Her granddaughter stood there for both of them. If this story stayed with you, share it with someone who needs to hear it today. The person who is preparing quietly, who is building something in a room no one else is looking at, needs to know that the building is not wasted.